Welcome to your first lesson, 5 ways to shield your mobile app idea. You have intellectual property. You may not know it yet, but you do. When you thought of your app idea, you have created intellectual property or IP that can likely be protected. Your IP includes what functions your app provides, how it looks, what it's called, the branding on it, and eventually the code for the app. And there may be aspects of this that you want to keep confidential as well, at least at early stages. These are all things that can be potentially protected and things that you may want to shield to add value to your mobile app and to also protect your mobile app idea from it being copied or stolen by others. A lot of people say to me, but I just have an idea. Can I still protect it? I hear this almost every single day. A lot of people wonder, like, well, I have an idea, but what can I protect with that? And if you look online, sometimes you'll see things that say ideas alone can't be protected. And that's not exactly true. I understand why people write that sometimes, but it's a bit misleading in my opinion, because ideas can absolutely be protected. After all, if you think of what we call these things, intellectual property, something that's created by your intellect, or basically an idea in your mind. And the short answer is yes, you could protect an app idea even if you're just at the idea stage. You don't have to do any development, and you don't have to be a software developer or engineer to protect your idea. It certainly doesn't hurt if you're the engineer or developer work coming up with your mobile app idea. In fact, many of my clients are technical folks, but I would say many others are not. So I'm probably about 50-50 of whether they're technical or not. So you can absolutely protect an idea without being a software developer or engineer, that kind of thing. So what we're going to cover in this lesson are the 5 ways to protect your app idea. The first way is through patents. Most people think of patents as, the thing that really protects new inventions, and that's true. So how they apply to mobile apps is there are 2 kinds of patents basically that are applicable to mobile apps. First is utility, and the second is design, and we'll go into that in a little bit later in a slide down the way here. But I just wanted to mention that patent is one of the 5 ways you can protect your app idea. Another way is trademark. Trademark protects the branding of your app. So you may want to think of famous brands or logos like the Nike symbol or Coca-Cola or the Mercedes car emblem. There's certain things that are so deeply embedded in our mind that when we see them, we immediately think of those products. And a lot of times we think of the quality of the products. So when we see Nike on a shoe, we expect that to be a good shoe. We see Coca-Cola on the label, and we expect a good soft drink. We see the Mercedes emblem. You expect that car to be well engineered and have maybe luxury features or those kinds of things. And so trademark protects your app idea in the same way. So if you think of some famous apps out there, you will notice that they have branding associated with them. So TikTok, for example, or Instagram or Facebook, you can think of those logos, or Twitter. And in your mind, you can almost see those logos and know, oh, that's the way I associate with that app. So trademarks can help you protect that aspect of your mobile app idea. Copyright is used to protect the code itself. So for software, once the code has been implemented, it can be registered for copyright protection. And so that's one way to use that to protect your app idea. Another way, this is probably a little less known to most people, but trade secrets can be used to protect software or mobile apps or other software and things like that. And trade secrets are basically used to protect anything that has value by not being known by others. In other words, it's like something that because you know it, it gives you value, but it would lose that value if other people knew it. So again, I'll go back to Coca-Cola on this one. They're one of the more famous trade secrets, and that's the formula to original Coke. It's only known by a limited number of people. The formula is guarded in terms of it being protected in a safe or something, some kind of physical security. And basically, they keep that secret. So they've been able to keep the formula for Coke as a trade secret for over 100 years. They decided to go that way with Coke instead of a patent, because patents get published and only last for, at the present time, they last 20 years from filing date. But Coke chose to go with the trade secret. And just a little trivia for you, one of the early investors or partners in Coca-Cola, the inventor himself was a pharmacist, but one of the early partners in that was a patent attorney from Atlanta. And so he reviewed what Coke had there, or what the pharmacist had in the Coca-Cola formula, and opted for the trade secret on Coca-Cola. And that has been in effect for over 100 years now. So that's a little trivia. Has nothing to do with app ideas, but just to give you an idea about trade secrets. And then finally, a non-disclosure agreement. I include this one in here because I think it's really important. People hear non-disclosure agreements or NDAs. Those come up all the time now in the news related to celebrities or government figures and things like that. But they're very important for your mobile app idea, especially if you're going to discuss it with others. And I'll get into that in the lesson on non-disclosure agreements. But basically, in this course, you're going to learn about non-disclosure agreements and certain features of them that can be very beneficial to you. There are things that you will not find in your generic non-disclosure agreements or NDAs. If you were to search online and look for a NDA example, you will not find what you see in this course. This one has been fine-tuned for protecting your intellectual property in specific ways, and you'll learn more about that in the non-disclosure agreement module. Going back to the patent side, there are utility patents. These protect the functions of an app. So you can think, to me, the easiest way to think of it is a utility patent is directed to the flow chart of what the app is doing. So kind of the overall function of it. It doesn't include code, so you do not have to have the software developed yet to apply for a utility patent. That's a very common question I get. And there are basically two kinds of utility patents. There's a provisional one, and that's what you'll learn about in this course, that you can draft and file yourself. They also have a non-provisional version of them, and that's one that kind of continues on with the process after a provisional, or a non-provisional can be filed initially. But in this course, you're going to learn how to file a provisional application, and the reason being is that it's got less formal requirements on it, but it also gives you a placeholder for your idea in the patent office, and that's important to get an early filing date, and it also gives you some flexibility that I'll discuss later in the provisional application module. Utility patents last for 20 years from filing date. They do have periodic maintenance fees due after the patent is issued. They're due at like 3.5, 7.5, and 12.5 years. So there's ongoing fees at those stages that you have to pay the government to keep the application in force. I've got an example here of a mobile app patent. This is a U.S. patent. You see there the numbers 5,960,411. We just say the numbers is 5,960,411. We don't usually do the millions and that kind of thing when we talk about patent numbers. And then once we show a patent number, we abbreviate it till our last 4 digits. So I would call this the 411 patent. This is one that's to the Amazon one-click ordering. So this was issued way back in 1999, and Jeff Bezos is listed as one of the inventors. I picked this one because it's something I thought everyone could relate to in terms of a software type patent. And also just fun that, you know, everybody knows Amazon and Jeff Bezos is always in the news. So I thought this would be kind of a fun one to use as an example. Here's the top portion of the patent, and you see the patent number in the corner, and this is what basically an electronic PDF version of a patent looks like. And one of the inventors in there you see is Jeffrey P. Bezos. And so this shows you that obviously Jeff Bezos felt that patents were important for software. And so that gives you an idea about what he thinks about them. And I pulled this figure out to show you what I mean by utility patent being basically directed to a flow chart. This is just a little simple flow chart. It's figure 4 of this patent, but it shows you what a patent diagram looks like. This is just an example and a nice simple one. But utility patents are basically directed to the flow chart or the functions of the software. There's also a design patent that can be applicable to mobile apps. Design patents protect the appearance of the app, and we think of that kind of like the user interface of the app. There's no provisional for design applications, so they just have one flavor, if you will, and that's just a regular design patent application. They last for 15 years from the filing date, and there are no periodic maintenance fees for design patents. So those are some nice features, really, if you think about it. And while utility patents are generally considered broader in terms of protection, design patents can be very valuable. There have been a number of high-stakes patent litigation cases between large companies such as Apple or Samsung and those kind of things that were directed to design patents. So they can definitely be very valuable. This is one I chose. Again, I chose an example to show you that I felt like people would be familiar with and kind of give you an idea about what Apple thought of design patents. This is the Apple slide to unlock patent from early iPhones. There's the patent number. It starts with a D, and that gives it tells you it's a design patent. And then the number there is a little lower than the utility patent number you saw a minute ago from 1999. This number is 675,639, but we would just call it D675639. We don't say the hundreds or thousands and all that stuff. But gives you an idea. The patents are issued sequentially, so you can see there's been a lot less design patents than utility patents. So utility is the most common patent used in the US, and design is second. Here's the top part of that one. It shows you who was the inventors and when it was issued. This patent was issued in 2013, which is kind of funny. But let's see a diagram from this design patent. And there you go. That's the diagram there. That's your slide to unlock diagram from figure 1 of this design patent. Design patents are mostly drawings. There's a little very short written part that goes along with them, but they're mostly about the drawings because they're about the appearance. They're protecting the appearance of this invention. And so you can see right there what I'm pointing at with that arrow. That is the feature that's protected. The rest of it is just shown for context in dashed lines, but that part at the bottom, the slide to unlock, is in solid lines. And that is what is being protected here. So now we'll turn to trademarks and how those protect mobile apps. Trademarks protect the branding. You can trademark a name as just the words. You can trademark a logo, a slogan. Trademarks can be maintained indefinitely if certain renewal filings are made. I have trademarks in my law firm that were issued back in the 30s, so well before I was born, and before my parents were born, and when my grandma or my grandparents were very young. So trademarks can go back a ways, and that trademark is still active today from the 30s. So it gives you an idea. They can go on a very long time. Here's an example trademark of Instagram. This is what the cover sheet of the patent, or I mean, excuse me, of the trademark registration certificate looks like. And so then now we're going to copyrights. Copyrights protect the source code for your app. Copyright attaches automatically. This is something kind of interesting about copyrights that's different from most other types of intellectual property. The copyright rights attach automatically when a work is created in a tangible medium, in the words of the Copyright Office laws or rules. So the copyright attaches automatically. The process you go through with the copyright is basically registering that right with the Copyright Office, which is a branch of the Library of Congress. The Patent and Trademark Office, the patent side, there's a patent side to the Patent and Trademark Office and a trademark side. So those are their separate agency there that handles both of those, and copyrights are handled by a branch of the Library of Congress. The registration process is used to register the copyright. Presently, they last like over 100 years. If it's registered to a company, I think it's 120 years right now. If it's registered to a person, then it's the author. The copyright law calls all of the creators authors, but it's the author's life plus 90 years. So copyrights can extend a very long time in the future, and when certain famous things come out of copyright, it usually makes the news. So this year, as I'm recording this, it's 2024, and so this year certain things have come out of copyright, like the original Steamboat Willie cartoon that had the first version of Mickey Mouse in it. And so that's entered the public domain this year, and that made the news a little bit at the beginning of the year. There's no renewal needed for copyrights at this time. In the past there was, but at the present time there's no renewal needed. So copyrights are nice. They're fairly easy to obtain, inexpensive to obtain, there's no renewal, and they last a long time. And there's one other little twist to copyrights that I think is interesting. Copyrights have both a civil and a criminal penalty. So if you've ever been in a movie theater and seen that FBI notice, that weird notice right at the beginning of a movie, or if you've watched back in the DVD or VHS days, there's this weird FBI notice at the beginning of movies, and that is about the criminal side of copyright. So it's one of the only IP protections that has a criminal side. And I only mention that because if something has a criminal side, the government will help you enforce it. On other patent and trademark, those do not have a criminal component. In other words, it's not a crime to infringe a patent or a trademark. And so the government won't help you enforce that generally. Sometimes they might in certain cases. But basically, those are all civil matters that you have to enforce on your own. Now, turning to trade secrets. Trade secrets protect information that has value by virtue of being secret or not known to others. It's implemented by a program to maintain the secrecy of the trade secret information. There's no registration for a trade secret, or there's no trade secret certificate that's going to come from any outside agency. It's just going to be something you maintain internally to a company, like the Coca-Cola formula example we talked about. No government filing, no renewal needed. You do have to do ongoing, like periodic training for new employees, and it's probably a good idea to do training for outgoing employees to remind them of their trade secret obligation and that the obligation does not end with their employment and that kind of thing. So there does need to be periodic training involved, but there's no renewal or registration with the government per se. Trade secrets have been in the news fairly recently with some really high dollar lawsuits. One of the examples I can think of with that is there's been high dollar lawsuits related to electric vehicles. Engineers leaving one electric vehicle company and going to another, or self-driving vehicles. So these have shown up a lot between the big players in the electric or self-driving vehicle markets. You can Google trade secret lawsuit electric vehicles, and you can see some headlines or examples if you'd like to do that. But it shows you the value of trade secrets. This is one that a lot of people don't think of, but it doesn't mean they're not valuable. Seeing these examples in the news and everything will show you just how valuable they can be. And finally, going to non-disclosure agreements. A non-disclosure agreement isn't technically a type of IP protection that you can register with the government, but it's like a contract that serves an important role in protecting confidential ideas such as your app idea. It's a document signed by you as the person disclosing the information and a receiving party. For example, let's say you needed developers to help you with your app. You would use a non-disclosure agreement with them. Or if you're pitching your idea to investors, even friends or family, you want to use a non-disclosure agreement with them to make sure that there is an obligation to keep your idea secret until such time as you don't want it to be a secret. But until that time comes, use a non-disclosure agreement. And there'll be some other things that we discuss in the non-disclosure agreement module that are kind of important, and those will tie back to the copyright aspect and back to the patent aspect. And I'll go into that in detail when we get into the non-disclosure agreement module. So this course for protecting your app idea includes a non-disclosure agreement template with special IP protection clauses in it that you can use. And those are the things I just mentioned relating to copyright and patent. And potentially trademark as well. But basically, there's some clauses in there that help protect you on that you can use if that's what you decide to use, and use that template. All right, thank you. That concludes the 5 ways to protect your app idea. And then I'll go into, now we'll go into each of the modules directed to the 5 ways. So we'll go into the non-disclosure agreement, the patent, trademark, copyright, and trade secret. And I'll see you in the next lesson.